everyone. I'm Paula Quincy from Engaged Humans, and we're all about facilitating connection and bringing the human back into the workplace. And today we're going to be talking about embracing diversity and navigating that rocky road that can often lead to conflict. And so I have some amazing guests with me today that are going to help answer some questions around how we can go about doing this. So I'm going to let them introduce themselves. Naz, over to you.
Hi guys, my name is Naazneen Khan. I am a partner with Botha at Dignified Dispute Resolution. I'm also an attorney, notary, and mediator. I work at BPG Incorporated, situated in Pretoria. So my primary focus areas include family law and commercial law, and I delve a little bit into maritime and archaeological law as well. And that's it from me.
Thanks, Naz.
Thanks, Naz and Paula. Good morning, everybody. I'm Karen Botha. I, as Naz said, am a director of Dignified Dispute Resolution. I'm also an attorney and a mediator. I specialize in my law firm in family matters, dabbling a little in other things, but mostly family law. But my main function and my main passion is conflict resolution and the peaceful resolution of conflicts in a dignified manner, and hence the creation of dignified dispute resolution.
That's amazing, ladies. I can't wait to dive into our topic today. And I know we're going to be talking about a couple of things that can lead to conflict both in our personal spaces and in the workplace, because as we all know, we are a whole person at the end of the day. And whether we like it or not, we do take home to work and we do take work home. And so how do we deal with us as a whole person? Naz, I
Yeah,
believe you want to
absolutely.
kick
I
off.
couldn't agree with you more.
Yes, absolutely. Thank you so much for that, Paula. I think that today's session is going to be completely informative because we're discussing conflict resolution and how they impact us in various avenues and aspects of our lives. And I think that the public and the community is going to have something to benefit today. If we have to go into the discussions today, I think my question to you is it's going to be first to you, Paula. And my question really is, in your experience, what role does community engagement play in addressing gender-based violence?
Well, community plays a key role, right? So let's define community. So if we're talking about the workplace, a workplace itself is a community. The organization as a whole provides a community environment where people can connect and engage and participate and thrive in. But then it also goes down into the actual team that you work within that creates a sense of community. And then obviously that relationship that you have one-on-one with your direct line manager. And then in our personal spaces, that sense of community is our immediate home environment, so our partner and our children, that creates a community that we operate and function within on a daily basis. And then working outwards, it's our extended family, and then the community that we surround ourselves in and that we operate within. So from a social point of view, from an interactive point of view. So community plays a key role because community gives us a sense of belonging, it gives us a sense of purpose, it gives us a sense of identity, and it gives us a sense of safety. It's a place where we feel that we are accepted, that we feel like we belong, and it's a place that we lean into when we're going through tough times, and it's also a place that we lean into when we want to celebrate good things. So community really is key. It's a key foundation to us as individuals feeling like we have a place where we can show up and be ourselves and we can belong, and also gives us a sense of safety. Which leads me to the question to you, Karen, which is, what is the difference between a mediator and a lawyer? Because we often hear these terms thrown around, especially when I work with individuals or couples and it comes to divorce. That's the first thing is like go for mediation versus going to court. And lawyers are so expensive and they're just there to take the money. So help us understand this.
Right. So a lawyer can be both a mediator and a lawyer. So like Naz and I are both mediators and lawyers, but they play very different roles and have very different functions. So I think the most important thing to remember is that as a lawyer, when I'm wearing my lawyer hat, I have a client, and that client, I look after their needs. I stand firmly in their corner. As a mediator, both parties, or if there are more than, excuse me, more than two parties, that all the parties are my clients. And I have to remain completely impartial. I never take sides. I never make any judgments on what any of the parties say to me. I'm there to listen and I'm there to facilitate a dialogue between the parties. Whereas as a lawyer, I'm there to, for want of a better word, fight for my client's rights. Then another difference is that as a lawyer, I offer legal advice. As a mediator, I cannot offer people advice. So, for example, as a lawyer, I'm going to say to you, this is the law, these are your rights, and this is my advice to you in regards to those rights. As a mediator, I can say, this is the law, this is the legal position, but that's it. I can't say, I think you should do X or Y. I can only provide them with legal information, not legal advice as a mediator. And of course, you referred to costs. Costs is a big thing. Legal costs can run from hundreds of thousands to millions of rands, depending on the complexity of the matter. And there's also the time issue. With mediation, it can happen quickly, and mediation could be done within a matter of hours sometimes, or days, or a couple of weeks, whereas litigation literally can take years. At the moment, for example, in the Gauteng division, if you are preparing for a trial, if you apply for a trial date today, you will get one in 2030.
Wow.
So people are waiting more than 5 years. So I think that's a very important thing to remember.
Sure, that's interesting.
Right, Naz, question to you. How does mediation benefit the parties? Why don't they just go to court?
Thank you, Karen. I think that my question relates a lot to what you've just explained in your previous question with regards to the timeline and costs. So I think in essence, it's not so much as they can't or they shouldn't go to court. It's rather that mediation offers substantial amount of benefits as compared to litigation. So like you said earlier, if we look at the aspect of costs, mediation can cost anything from 12,000 to 20,000 Rand, depending on the experience of the mediator that you go to, or depending on the hours of mediation that it takes to resolve your conflict or your dispute. Whereas if you're looking at costs in relation to litigation, it can go into the hundreds of thousands. Why? Because there's several aspects to litigation. Then coming to the timelines that you spoke about, as you said, mediation can be resolved within a day, within 2 days, if more mediation hours are needed. But if you're going to court, like you said, you're sitting at 2030. So a person who is owed like a sum of money or anything, and they really, really need that money back, they're sitting to wait to see whether they can get that money back in 2030. And then you're looking at the aspects of whether that person is even going to have that money to refund, whether that company is going to be liquidated by then, whether they're going to be in existence by then. So there's a lot of problems that come with the timeline as well. Another aspect, very important aspect, is if you consider the control and flexibility that the parties have when they're mediating. So when parties mediate, as you said earlier, that you're wearing different hats and you're an unbiased person helping these parties to navigate their disputes in a way where they actually have control over their own decisions. They have the flexibility, they have the creativity to come up with different ways to resolve their conflicts that suits them, and where they're actually leaving this dispute with happiness, and then another aspect of that is that as humans, we have relationships with one another. I like to say that conflict arises from relationships, because when you have relationships with one another, it causes conflict. Conflict causes disputes. And then you got to ask yourselves, how can you navigate this in a way where you are still retaining your relationship, in a dispute without, the bitterness that comes with receiving a summons or, proceeding with litigation. And then lastly, parties are then more amenable if they're coming up with their own solutions to actually adhere or to comply with those agreements. Why? Because they're involved in the process. So in essence, mediation actually brings a sense of dignity to any kind of dispute or conflict resolution. Why? Because the parties are feeling heard. They're feeling like their opinions matter. So yeah, I wouldn't say that litigation is not completely out of the window, because there are matters that cannot be litigated, such as matters involving criminality. Criminality is not a dispute. It's that's in public interest. So it's in public interest to get an order. But in almost all other matters, it can be mediated. Yeah, that's it from me.
Thank you, Naz. I think one of the important takeouts that I get from that is that mediation is very empowering, because instead of having somebody else make a decision for you, you get to actually make the decision yourself. I think that's something that's very
Yes,
important.
absolutely.
So, Paula, next one for you. And I'm fascinated to hear the answer to this, because I know some of it, but some of it boggles my brain. What is meant by DEIA and B? This like new catchword. I'm really curious to know the answer to this one.
Yeah, it's come about since COVID, this new acronym or term. We are more familiar with DEI, diversity, equality, inclusivity, so pre-COVID days. And just the legacy of our country and where we've come from. When we spoke about DEI, we automatically kind of defaulted to a gender thing and a race thing, because of the legacy of where we've come from. And I mean, that is still true, but in today's world, it is much more than that. So DEIAB is diversity, equality, inclusivity, and now what people are really looking for when it comes to employees, but just people in general, and Naz spoke about people in relationships, whatever that relationship might be. We're looking for acceptance and belonging. We want to know that we can show up and we can just be our true, authentic selves, that we can be seen as this whole person. And so DEIAB is no longer just about race and gender. It is about, how do I see and hear all the voices in the room? How do I embrace that diversity? And that diversity means different cultures, traditions, backgrounds, qualifications, educations, experiences, opinions, and views, and that it's not right or wrong. It's both and. So how can I hold a space for both and? Both your view and my view, or your view and the other person's view, and still, by hearing that person's voice or making that person feel that their voice is heard, that their contribution is heard, resulting in that sense of acceptance and belonging. I feel like I am seen as a human being. I feel like my contribution or my input is being valued and respected and appreciated. And that's what people are really looking for with the work that we're seeing, especially in the corporate environment when it comes to the values and culture work that we do. But also in the individual space, especially when it comes to working with relationships, whether it's family businesses or family relationships. People just want to feel like they belong, and they want to feel accepted, and they want to feel safe. So safe, the buzzword in the corporate space, psychological safety, in the personal space, emotional safety. We want to feel safe enough that we can say what we're thinking, say what we're feeling, without any fear of judgment or ridicule or being dismissed or invalidated.
Yeah, I actually love the what you just said right now, because that kind of ties into my next question, which I'm going to direct to you, Karen. But the essence that I take from that is parties just need to be free to express themselves, and that's also a very important aspect of mediation. So having said that, to Karen, when we're mediating incidences where there are power imbalances and people are incapable of expressing themselves freely under normal circumstances in the workplace, divorces, or any other scenario, how can we as mediators then create an environment where all the parties are then free to, or feel safe rather, to express themselves freely?
This is a very good question. Thank you, Naz. And it ties into what Paul has been saying, especially about the safety. And it's one of the most important things as a mediator to create a safe space. And again, what Paul was saying about acceptance and belonging, the mediator's role is to hear people. That's what we do. We hear people. So when there are power imbalances, and very often in disputes, there are power imbalances. So examples can be in the workplace, an employer-employee type power imbalance. In a business dispute, it can be the financially stronger business versus the less financially strong business. In a marriage, it can be the one party is the financial, backbone of the relationship and has been the provider. So those kind of power imbalances are very often present. So what's important is that prior to the mediation even taking place, the mediator should conduct a pre-mediation interview with the parties separately so that they can assess the dynamics and first of all ensure that mediation is appropriate, because in some circumstances, like you said, Naz, mediation may not be appropriate. So, for example, if there's gender-based violence in a relationship, so in a divorce relationship, for example, you may want to, it may be necessary to determine that mediation is not appropriate. And then the mediator should also establish very clear ground rules to prevent any kind of intimidation or coercion taking place during the sessions. For the mediation, the mediator should use a very neutral and private space where the parties feel physically and emotionally secure. And importantly, offer separate rooms for what we call caucus mediation, so where we're just with one of the parties. Because people are far more likely to express their views when they're alone with somebody than when they're actually facing the person they're in conflict with. That can, where there's power imbalances, especially, be that situation alone can be intimidating. And now this one comes into what Paula has been saying. Active listening is one of the key skills that a mediator has, because by actively listening, the mediator validates their concerns and allows each party to have sort of equal speaking time to express how they're feeling. As I said before, when you can make use of separate rooms. We call this shuttle mediation. So where there's quite an extreme in power imbalance, you can use shuttle mediation where the parties literally sit in separate rooms. We can even do that on Zoom. And the mediator shuttles between the parties, speaks to one, then moves to the other. That can also give the parties a feeling of safety, that they're not in the room with that person. So it's obviously very important that a mediator remains very vigilant of any signs of coercion or distress in either of the parties and makes adjustments in the mediation process as necessary. That's what's so great about mediation. If one of the parties is becoming distressed, you can give them a timeout. Or you can say, today we've done enough. There's a lot of emotion in the room. Let's take a break and let's reconvene tomorrow or next week or anything like that. So mediation is lovely and flexible, given the contrast in litigation where if you've got 3 court days, you're going to court for those 3 days. There's no time to tap out and take a break and just regroup, if you would. I hope that's helpful.
Definitely. And I think it's a great segue into my question to Naz, which is, especially with the divorce rate being so high that it is these days. So is mediation in South Africa mandatory? I mean, is there any legislation or court ruling that says that parties need to attend mediation before they go to the courts?
Thank you for that question, Paula. That's actually a very, very good and important question that needs to be asked. And the simple answer is No. So mediation is not mandatory at all. There's no legislative provisions that make it mandatory. Mediation is a completely voluntary process by the parties that are involved. What is mandatory, though, is the Rule 41A that all attorneys know about. This is basically a notice that is mandatory to be attached now to all your summons and your applications that you're bringing in court. And that's simply to say, whether you agree to mediation, whether you're amenable to mediation, and if not, then you need to state your reasons. So that's exactly what it is, and it stops there. So it's basically a tick box if you have to look at it. You know, all attorneys, they say, yes, we're amenable to mediation, but then nobody actually decides to act upon it or mediate upon it. But if one party has to then decide, okay, what do I do with this notice now? This party did indicate on this notice, this Rule 41A, that we want to mediate. What is the next process? How can I force them to mediate? How can I force them to act upon a notice that they've done themselves? There's absolutely nothing. So then we've got to ask, what is the value of the Rule 41A? What is the purpose of it? None of us really know. But having said that, I would also say that the Children's Act, I think it's Section 33 and 4, if I'm not mistaken, does provide for, they strongly recommend rather mediation, particularly in matters involving children, because of the impact that litigation has on children, obviously. But other than that, it's still not compulsory for you to go to mediation to try and mediate these matters. And that is why our children's court is also sitting in a complete mess currently. At most, you'll have your judge or your magistrate telling you to go outside and try to negotiate. But once again, that's still not mediation. There's no unbiased third party assisting you to navigate that conflict, to come to a decision that's beneficial to both parties. Each attorney is now there saying, this is what we want, this is what we want. And that is why you go back into the court and you're like, we didn't manage to negotiate. Why? Because all we're doing is standing outside and saying what we want. We're not coming to some sort of compromise. So no, there's no there's no legislation, and I think that's something that we actually need to work towards and address.
Sounds like it could be a valuable tool.
Yeah.
Yeah, I think Naz as well, flowing on from that, as a litigation attorney myself, many matters are what we say settled on the court steps. And people must be careful not to confuse that with mediation. Like Naz says, that's negotiation. And it's actually the wrong time to try and resolve a dispute, because you're about to go into a trial and you're now under pressure. And so you're actually not negotiating from a place of safety. You're negotiating from a place of fear. So you want to try and mediate long before you get to that position. Anyway, thanks, Naz. Very informative. Paula, next one for you. Back to our D, E, I, A, and B. Why is it important that we integrate this into organizations?
So it's key because it forms a key component of an organization's culture, right? So just as parents create the culture and the home environment for children to grow up and thrive in, so too does leadership create the culture or the tone for employees to thrive in. And if leadership really embody and embrace the DEIAB, so embracing diversity, equality, inclusivity, acceptance and belonging, first of all, within their leadership team themselves. So as a leadership team, how are they embracing each other's diversity and creating an inclusive space, for all voices to be heard, and modeling that behavior? And then how are they flowing that down into their own respective teams? Because just as children mimic parents' behavior, good or bad, employees will do the same. Employees will mimic leadership's behavior, and they will mimic the behavior that is being acknowledged and recognized. And that doesn't necessarily mean it's the kind of behavior that you want to embed as your culture. And then very closely to that, is it aligned and integrated with your values of the organization? Because your values are your moral compass. Your values underpin your thoughts, your actions, and your behaviors, and it drives every decision that you make in life, whether it's personally and or in the workplace. And so if you really want to build a healthy culture, um, you need to bring this in. You can't not have it because it links directly to your values, which talks to behavior of everybody in the organization. And there's enough research and data out there that shows there is a direct impact on the organization's productivity and bottom line. And there's also enough evidence out there that organizations that have embraced diversity from a leadership point of view, so across gender, across race, across culture, and all of that, are far more revenue generating than the organizations that haven't embraced it.
Thank you, Paula. Something that caught my mind rather from the conversation that you just had is behavior. So I think that behavior is a very important aspect to consider when you're dealing with conflict resolution and conflict management. And that assists us in resolving a dispute and assists us in tailoring our approach then to resolve the disputes, because behavior and how people react in certain manners or in certain ways contributes to how disputes arise. So that goes into my next question for you, Karen, is that a lot of the time, our behavior is caused by certain things that occur in our lives, such as trauma and such as grief. And these kind of things cause conflict. So how can we as mediators then tailor our approach to help parties reach dignified solutions, particularly in regard to matters involving grief and trauma?
That's a very good question, Naz. Thank you. And I think it also ties into what Paula was saying earlier with regards to our diversity, because our diversity can in itself create trauma. Mm-hmm. So I think the most important thing is that we need to understand trauma and grief and the effects of trauma on the human being and their behavior. We all are suffering from some kind of trauma. You could have a room with 10,000 people in it. And if you said, please raise your hand if you've never experienced trauma in your life, and I guarantee you not one person would be able to raise their hand. I mean, you might have an absolutely blessed life, but at some point in your life, you've suffered trauma, your brother chasing you around with the garden fork or something. Things happen. You might have a motor car accident. It's trauma. So as a mediator, we need to educate ourselves about the effects of trauma and grief on especially how people communicate, how they make decisions, and on their emotions. Because obviously as mediators, we're helping people to communicate. So if we don't understand their trauma, we can't understand how they're communicating and what might be blocking their communication. The other thing that's very important is we need to be patient when there are heightened emotions in a room. And as I said before, we can slow the process down. We can allow that party who's feeling the emotions, first of all, we're allowing them to express their emotions, which in court, if we were to litigate, you want to keep the emotions out of it because that's just going to cause you issues when you're sitting on the stand expressing your emotions and getting angry or whatever the case may be. Whereas in the mediation space, because it's safe, people can express their emotions. So the mediator is creating a non-judgmental and supportive environment where a party feels that, going back to what Paula was saying, they're being heard and they're being understood. So again, this is done through active listening and reflecting and validating the feelings and expressing empathy, demonstrating that you're empathetic to that person, not sympathetic, different, but empathetic. Putting yourself into that person's shoes and imagining how it is they might be feeling. Again, like I said, the being able to be flexible with the timeline is very important. You don't have to rush it. And then I think one of the most important things is when it's appropriate, stop the mediation and refer the party who's experiencing or possibly re-experiencing trauma because of what's coming out, is to refer them to a specialist, a therapist or a counselor or something like that. And in those kinds of situations, also allow them to have a support person with them in the mediation. There's nothing to stop them from doing that. You know, in a court hearing, you can't have that. But in mediation, you can allow them to have someone who they feel safe with in the mediation with them. So those are the steps that mediators can take. Being informed and educated, most important thing.
I think that's a great lead into the question that I have for you, Naz, because I think there's a perception out there that mediation is only for couples going through a divorce. Is that true, or can other people also benefit from using mediation?
Thank you for the question, Paula. Not at all, actually. And I'm going to tie into some things that I just listened to with Karen's answer. The thing with mediation, or the mediators rather, as you can see throughout the discussions that we've had today, is that mediators have to not just wear a mediator cap when they're sitting in mediation, but they've also got to be like multiple personalities. They've got to be psychologists, they've got to be mediators, they've got to consider the aspect of legality as well in every respect. So there's a lot of things that mediators then become apart from being a mediator in order to consider how we can tailor our approach. So no, mediation is not just for divorces, as we have seen throughout this entire conversation. There's various different aspects. It's so versatile that we can actually tailor our approach to different situations. So, for example, one of DDR's focuses or projects rather is a focus on mediation in the workplaces. You know, we're in workplaces, constant conflict, as we have highlighted throughout this webinar, throughout this chat. With conflict, it can actually affect people's work performances, employees' work performances. Mediation can actually then be tailored to suit conflicts on all sorts of levels in that department, whether it be aspects of managerial positions, aspects of employees, all from the in the hierarchy from the top right to the bottom. Mediation can be tailored to suit those approaches. Mediation can also be used in commercial matters between business partners in business conflicts. You know, business partners having a conflict with regards to certain things or certain premises that they're going to use, or certain aspects of dispute resolution within their own company, whether it be between businesses and clients. Those are things that mediation can be tailored to actually address. Then if you also look at aspects of disputes between countries, mediation can actually be used to be rather be tailored to suit mediations on very, very high levels. So where countries are actually experiencing disputes with regards to governance, with regards to treaties and that kind of a thing. I mean, you look at back in the day, how mediation was probably used in the ancient times before wars, where people would mediate and try to come up with certain, alliances with each other to prevent wars. Mediation has been used constantly throughout time. Mediation needs to become mainstream going forward, because this is the type of thing that's going to resolve conflicts without the various problems that we've highlighted today in everybody's questions. The problems that we have in South Africa with regards to the courts, with regards to costs, with regards to time. Like I said before in previous of my answers, litigation is not always taboo or not the way to go. In certain circumstances, that's the only choice you have. But you'd rather try and mediate your matter first in all kinds of disputes. Mediation is universal, and I believe that mediation should be your first priority before you decide to even think about litigation.
Thanks, Naz. Thanks, ladies. I think if I'm taking anything away from our conversation today, it's that diversity is going to result in conflict at some point, somewhere along the line. And that conflict can be as simple as a disagreeing in terms of a view or an opinion or an idea, and that's okay. But when it does start becoming, I guess, destructive, in that it starts causing damage of some sort, so like a breakdown of a relationship, or hopefully before it gets to that stage. There's no harm in seeking help from a professional, and that mediation can play a key role here, both in the business world and in the personal world, to try and resolve things in an amicable way before going to that last resort of heading to the courts, which can cost a lot of money, number one, but number two, it can also just cause a lot of trauma and hurt and pain. And we're all suffering from enough trauma as it is in this world. We don't need to add more trauma to the world.
Absolutely.
Definitely.
I think one of the important things, Paula, relating to that last question to Naz, is that mediation doesn't just have to happen when there's a matter that's going to go to litigation. I think that's a misconception that a lot of people get. So mediation can happen in any matter. Let's say, for example, I I was actually told this as an example the other day. They're neighbors. One of the children are playing out in the garden, and one of the children kicks a ball over the fence and knocks over and breaks the neighbor's garden gnome. Now the parties go to court because the one thinks that that's harassment and wants a harassment order against the neighbor and the neighbor's child. That's a matter that needs to be mediated. How can we resolve this? Can
But
we buy
wait,
you a new garden
who
gnome?
who
Can
was
we
harassed?
apologize? What's that, Naz?
And like, who was harassed though? The garden gnome or
Or maybe garden gnomes have rights too. But I think that's the important thing, is that it doesn't have to be because you're going to go to court or because you're already at court. It's better to do mediation before you even start thinking about that. Because once you start the litigation proceedings, things have already escalated. And you want to try and avoid that. I think that's so important. And I think understanding that in mediation is useful in any situation, and it doesn't matter what your diversities are, whether the parties are the same culture or different cultures, and mediators come from a vast array of diverse cultures, religions, languages, and that's very helpful because people can, use that as a conflict resolution rather than going to court all the time.
And to
I
be
think
kind, carry on, Naz.
sorry, Paula. I think if I have to also add on to that, a lot of parties choose to litigate over mediation, and this is it's a wrong idea that they have. They choose to litigate over mediation because they have this mindset that they want to have their say in court, or they want to be proven right. But more often than not, if you think about it, parties go to court, spend thousands of rands, hundreds of thousands of rands. They resolving their disputes over 2-3 years. They're creating a bitterness and destroying relationships that existed, and then you reach an outcome that you're still not happy with. So more often than not, at the end of those 3 years, the judge is sitting there and saying, "Well, you know what? Your garden gnome is this much, and this is this much. It's so many years down the line. I don't think it's necessary, and I'm not going to grant you costs for this because it shouldn't have come to court." You know. So you then spend 100,000 rand over a garden gnome, if you think about it, and you're leaving there poor, you're leaving there losing time out of your life. That this is 2 years, 3 years out of your life that you're dedicating to bitterness. So I think that's something people need to think about.
Yes, definitely. So thank you, ladies, for sharing your insights, and to everybody listening, be kind to the garden gnomes because they have rights too.